Learned District and Session Judge, Principal District and Session Judge Gangtok, Learned District and Session Judge, Special Division 1, Learned District and Session Judge Subarna Rai, and Ms. Ranjita Pradhan, and Learned Judicial Officers. Actually this session was to be conducted by Sri Prajal Khatiora, but due to his engagement in the chief store, he could not come today, so I was called in to replace in the last minute. We all have been doing these administrative duties in one form or the other. Even judicial magistrate who are particularly stationed at their subdivisional courts. And chief judicial magistrate also, I think Ms. Urvashi is also doing. Paring Jwala for your office, I think you will be doing your administrative work. Perhaps in the CRPC also, CJM has the administrative power. In one of the provision it is there regarding case management and arrangement of things. So we all have been a part of that process, especially in the judiciary. We do have to look into certain administrative works. And for new judicial officers, even as a judicial magistrate, as I said, specially posted in the subdivisions, will be invariably doing some kind of administrative works. And for CJMs and other GMs in the district also, sometimes district judges may delegate you some work to be done. And particularly when you are the secretary of DLSA or the chairperson of Taluk Legal Services Committee, you will invariably doing administrative works. Basically, it means that you will be having some people subordinate to you under your control, whether direct or indirect. So some kind of management or some kind of issues may arise during the administrative work, and particularly the today's topic is relating to the disciplinary inquiry. Now we all have studied this law, but we nowhere use this as we progress in our career as magistrates also. We have studied this law, and it is a very much part of a public law, the administrative law. Well, this public law is a huge one. It deals even with separation of powers between the government executive and the judiciary, so on and so forth. But let us stick to what it deals with, the pure administration or the executive, which may call. Now, as we know, judiciary functions independently, right? At the state level, the Honorable High Court has the power of superintendence over the district courts. And it is the ultimate highest body in the state when it comes to judicial function. Even Supreme Court is not administratively superior to the High Court. But the rules that govern our services, including the district court staff services, are framed under Article 309 by the state, right? Though High Court has the power of superintendence, but that particular article does not provide for the power to make rules. So somehow we do not have the rules made by the High Court that deals with the disciplinary proceedings of the staff employees, including us. It is done under state government rules. I have had 2 experience in conduct. Some of the district judges, I think Madam Subarna also has 1 experience in conducting this disciplinary proceedings. I have done 2 disciplinary proceedings, one as a presenting officer and one as an inquiry officer. Sorry, one as a disciplinary authority, which dealt with these, I think, Group C staff. So, administrative law has certain fundamental principles. We are concerned with the first and the last one, and not the middle one. Rule of law, as we all have studied that all are equal before the law. The rule must be applicable to each and everyone in a fair and transparent manner, no matter the status. As it says, fairness for everyone. The clear and consistent laws are quite a broad topic, which we need not go into that. Limits on government power. This also in the wider, in a broad concept. The administrative law also deals with the limits on the power of the government power, as we cannot be arbitrary. Otherwise, if there are no rules or if there are no principles or guidelines laid down, then the authority will have a tendency to be arbitrary. And one of the most important things that in the disciplinary proceedings that is always an issue is the principles of natural justice. There are questions that, so, one of the officer constantly kept on asking me whether he should do 313 in the disciplinary proceedings. Okay, I'll come to that a little later on. It's related to these principles of natural justice. Now, right to fair hearing, we all know. No person should be condemned unheard, right? And then, right to fair hearing not only encompasses the right to be heard, but also the due process that is to be maintained must be fair. By due process, we mean all those processes that are available to any delinquent, or in case of criminal trial, the accused, or in case of civil cases, the parties. No favoritism is a part of not being biased. Reasons for decision. Now, this is also very important. We cannot leave our decisions unreasoned. Anything we do, there has to be a reason. And it will always be on the safer side, even if small, to give a reason for your actions. Chance to respond, of course, it means the defense of the person. As I said, where there is a room for discretion, there is room for, yes, arbitrariness. This is a sentence which runs through every thread of every proceeding, whether criminal law or civil or disciplinary proceedings, whatever it is. It's a human which decides. So where there is a room to play a discretion, maybe we intentionally may not do it, but there will always be a chance to do something that will appear arbitrary from the reasonable man's point of view. So, having dealt briefly all the disciplinary proceedings, the rules which we have come from the domain of administrative law, which is actually not a written law in one form. Administrative law is a compilation of all those rules, guidelines, principles of natural justice, etc. that forms a system of a law within which we are to function. You will not find any codified as such an administrative law. We all know that. But of course, it may be codified into forms of rules, etc., which will be a part or a subcomponent that is drawn from the administrative law. So what are the essential requirements we need to adhere to during the inquiry proceedings? As I said, principles of natural justice. Most of the writ petitions, the disciplinary authority loses the case on the ground that procedure is not followed. And in that procedure, it involves usually the person was either not given a right to be heard, or he was not given the opportunity to defend himself. These are very crux, whether in criminal law also. If you see the disciplinary proceedings, it is so much similar to the criminal law which we do, minus some certain things. Otherwise, the process I find is similar to the trial which we conduct in the court, the procedure that it follows. Now, sometimes why this happens is that no disciplinary authority would like to be told you did not follow the procedure, and ultimately the inquiry gets quashed, including the punishments. Sometimes it is the ignorance, especially in the executive. We have seen that because disciplinary proceedings takes under certain rules. When rules comes in, it has to be interpreted. Those who are not well versed in law, or those who have not studied law, or those who have not been briefed properly that this is the process what the rules are saying, then the executives always falter to stick to the procedure. This is the most common ground on which the inquiry proceedings are quashed. As we know, the writ courts cannot replace their opinions with the opinions of the administrative authority. No matter how harsh it may seem, the courts cannot sit on their place and decide for them. The decisions are usually not overturned, the conclusions, but the process by which the decision is reached is almost every time overturned in the writ petition. And of course, the writ court would say you may do the procedure again. And it's up to the disciplinary authority to whether to reconduct the inquiry proceedings or drop it. In a sense, the employer is, a dominant person or institute which has its say in whether to conduct the inquiry proceedings or to drop it. No one can say that, okay, you have to do the proceedings against the particular person. Usually they are the appointing authorities. Okay? Fair hearing. Now, what would fair hearing encompass? The rules under which we deal this inquiry proceedings sometimes say, especially during the appeals, that the person may not be heard in person. Our rules, to the extent at one point say, which is quite contradictory to some other points which the rules speak of, that during the appellate stage or while granting punishment, you need not hear the person. That also the rule says, but we will deal that little bit later on. Opportunity to be heard. Something either in writing or in person or through someone, some kind of opportunity must be afforded. Just that because the person did not approach before you while called to face the proceedings does not mean that he did not come and therefore I will not hear him. As we all know, as judges, we do give opportunities to in criminal trials. We invariably have to give opportunities. Even in civil, there are so many processes which is actually the court trying to give opportunity to the person to come and participate in the proceedings. So you must remember that just because the person did not come once, you proceed directly. There are small things which which ultimately will be challenged and your whole process will be brought down. So try to bring the person, unless it becomes so unreasonable to call him that, or he does not appear despite repeated reminders, then you can proceed. But always give a chance. A second chance is required even in these proceedings. Rule against bias, as we all know, it's not that administrative law, I still remember it clearly told. There is one sentence in administrative law which clears what it means by being biased. It is not that you are actually biased. Okay? Is that if the person who returns from your court or from your office and feels that you are biased, that is sufficient to constitute a bias. I may be absolutely impartial, but certain acts of mine or certain things which I do may give an impression that the person is, that the court or the inquiry officer is biased. Now that apprehension, when the person takes from you, it's his feeling that comes, that really determines whether the court was biased or not. So therefore, we need to be absolutely impartial to give any kind of such apprehension. What could be those situations? There is also one doctrine of necessity which we will discuss later on, which says that in the administration sometimes it's these as against the nemo judex in causa sua. Sometimes the administration is structured such a way that there is no other person available than the one who has some kind of interest or involvement in that certain proceedings. Though legally, if tested, may not stand the test of law, but this doctrine saves such procedures as well. There cannot be two district judges. Sometimes the situation may come that he is the sole authority to do both the things. So in such cases, the doctrine of necessity may come in hand. Now, what involves this inquiry proceedings? First, there must be someone who has derelicted in doing so. I've used a broad term dereliction. There could be so many things. A person may be, an employee may be involved in a criminal action also, sometimes civil also. Okay? So there must be a violator who becomes the subject of inquiry, right? The next process is the inquiry. Now, who conducts inquiry, how it is done, will go on later on. Then there is authority. Sometimes the disciplinary authority and the inquiry authority is the same. At times, usually it is different, but many times it could be that the disciplinary authority itself inquires into, instead of delegating it to the subordinate officers. After that, the conclusion is reached, whether the person against whom the charge has been framed is guilty of those charges or imputations that are made against him. Now, as I said, employer is the sole decider in this case, as it is his employees. 10 of the Constitution of India, except as expressly provided by this Constitution, every person who is a member of a defense service or of a civil service of the Union or of an all India service or holds any post connected with defense or any civil post under the Union holds office during the pleasure of the President. Right? And every person who is a member of a civil service of a state or holds any civil post under a state holds office during the pleasure of the governor of the state. Let's take for example our officers who have been recently joined, right? They were recommended by the High Court, right? And then they were appointed by the government. But the pleasure is of the government whether to appoint it or not. And removal also is the same. So the words pleasure of the governor or pleasure of the president legally doesn't mean that you can throw anyone at any point of time. There's a process to go through it, that is the disciplinary proceedings. But yes, I'll show you later on or something also. Notwithstanding that the person holding a civil post under the union or a state holds office during the pleasure of the president or, as the case may be, the governor of the state, any contract under which a person not being a member of a defense service, so and so, this is not required. Let's go to Article 311. Dismissal, removal, or reduction in rank of persons employed in civil capacities under the union or a state. No person who is a member of a civil service of the union or an all India service or a civil service of a state or holds a civil post under the union or a state shall be dismissed or removed by an authority subordinate to that by which he was appointed. So the dismissal is always by the appointing authority. There are some overlapping between the appointing and the disciplinary authority at times, but yes, no one can be removed by anyone who is subordinate to the person or the office which to the appointing authority. No such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. Provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making representation on the penalty proposed. Provided further that this clause shall not apply when a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction or a criminal charge, or where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded by that authority in writing, it is not reasonably practical to hold such inquiry, or where the president or the governor, as the case may be, is satisfied that in the interest of security of the state, it is not expedient to hold such inquiry. So clause C may not matter to us, but clause B, if you see where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded by that authority in writing, it is not reasonably practical to hold such inquiry. So every cases may not require the conduction of inquiry to dismiss a person. Of course, legally it will always be challengeable in the writ courts. But one of the situations that comes to my mind is this could be, I have not read in the service rules, it could be applicable to the officers who are on probation. Usually in the probation orders, some of the officers I have seen that they are also writing that his removal will be, there will be no necessity to give reasons for the removal till they cross the probation period. In civil services, I have not seen that, but this could be the clause that can be used to remove an officer on probation without holding disciplinary inquiry. Because a certain conclusion is reached by the appointing authority that the person may not be fit. There could be many other situations where, so therefore it is not every time essential that an inquiry has to be had. Ordinarily it will be had, but there may be compelling situations, reasons that are recorded by the authority in writing and said no, we will not conduct the inquiry. So it is not that every time inquiry has to be held, and this flows from the Constitution of India, and the rules do incorporate this in one of their clauses. So it is not that inquiries or rules are being made or framed somewhere just blindly. There is a constitutional provision which also deals with the dismissal and inquiry proceedings of a delinquent. there's one topic also, suspension. Every time suspension is not necessary. A disciplinary inquiry can be conducted without suspension also, but usually suspension is done when there is a contemplation of disciplinary proceedings. So if there is a complaint against a particular employee and the appointing authority is of the view that we have to suspend him, and a proposed disciplinary proceedings is there, then a person can be suspended. What follows after that is it makes a difference, I think, in his pay scales which he is drawing. That relates to the different rules. But yes, employee can be suspended pending inquiry, or may be allowed to continue in service even when the disciplinary proceedings are going on. Another ground of suspension is engagement in activity prejudicial to the security of the state. We are not a little bit concerned with this. Criminal case under investigation. Suppose if there is an FIR lodged, an investigation began, that can be a sufficient ground to suspend an employee, even though there may not be contemplation of disciplinary proceedings. So both way it works. You may be contemplating proceedings independently also if there is a case under investigation, and the authority may not be proposing or thinking to conduct the disciplinary proceedings or inquiry against him, a person can still be suspended. And conviction of an offence. Now when this number 4 comes is that the authority has not suspended the person during the investigation or trial. Okay, but when there is a conviction, usually what follows is suspension. And as we all know, there is no bar to conducting parallel criminal trial and disciplinary proceedings. Both are different fields of law. Now our rule particularly says that 48 hours, a moment a case is registered and the person is detained, it uses the word, 48 hours or more, an automatic suspension comes in. Now they call it automatic because the rule says 48. They have to. Actually it's not automatic, it does not happen itself, but the moment 48-hour process. And usually if you see in your experience, especially the magistrates, the vigilance police usually brings the accused persons on Saturday before you. Sunday the court is closed, the bail is gone, or Fridays on second Saturday is there. I have seen that. And the 48-hour gone, the person is suspended. Conviction of an offence, yes, and it begins from the date of start of investigation in case of investigation, and from the date of conviction, the 48-hour begins from the conviction of an offence. Because I think this rule is there because criminal proceedings against a government employee is not a small thing. Conviction is far more greater. But once the criminal proceedings is there against a government servant, then prudence would require that he should be suspended. So this automatic rule comes into play. Now what includes dereliction, right? Because nowhere it is defined that this act of an officer is a dereliction and therefore he should be suspended or inquiry should be started against him. It may usually, as I said, coming in conflict with the law, or it may also include acts against the law, which is generally, or any such acts which is so connected with the performance of his duty. So any act, it could be anything, whatever we could imagine. Being absent regularly may also constitute dereliction. Coming drunk to the workplaces unnecessarily, despite reprimands, may also invite these actions. Anything you can think, including a second marriage when the law prohibits it. Does it include then moral turpitudes? Yes, it includes that also. It means in general sinfulness, wickedness so extreme a departure from ordinary good morals. It means vileness and depravity. These may not be an offense in the criminal law, but if it is against the established morals of the workplace or of the society also, can be sufficient to invoke disciplinary proceedings against an employee. The very word discipline means the government servant is to do his duty, which includes adherence to such established morality as is acceptable to all. So the inquiry for even the district court is conducted under Sikkim Government Servants Discipline and Appeal Rules 1985. We do not have our own rules. This is the rule that is applicable when you start disciplinary proceedings. Now, to whom does it apply? If you see, to every person appointed to a civil service or post in connection with the affairs of the state of Sikkim and who is subject to the rule-making power of the government. The last one is very broad, who is subject to the rule-making power of the government. All employees are subject to some kind of rule-making authority of the government. So these people could be the subject, including us. Right? There's one body called disciplinary authority, inquiry authority. Okay? Within that inquiry authority there is a presiding officer and there is a delinquent. Now, what role does disciplinary authority then have to function? To draw up a charge. Now this is very important. Supported by imputations of misconduct or misbehavior. The inquiry authority never draws a charge. The charge has to be drawn by the authority which is contemplating disciplinary proceedings. In case of us, the High Court. In case of officers in the district judiciary, whatever group they are, B, C, D, right? It is a district judge who is the disciplinary authority, because the appointing authority is the district judge. Except there is one exception in this, the High Court Computer Card of Service Rules. Their appointing authority is High Court, so their disciplinary proceedings have to be initiated by the High Court. Now there's a fine distinction between appointing authority and disciplinary proceeding authority when it comes to us, right? If you see, we are appointed by the governor of the state, but the High Court, which has a superintendence over the district courts, acts as a disciplinary authority in case of judicial officers. Now, charge has to be drawn. How a charge is done? Some imputation is there. Someone has complained, or there are certain documents or evidences even available at that stage to charge you. So, charge, which is also known as memorandum of articles, is usually drawn by the disciplinary authority. If there is one charge will be done. If there is more than one charge will be drawn and send it to the inquiry authority if the inquiry is delegated. If it is not delegated, the disciplinary authority itself provides the articles of charge to the delinquent employee. It must always be supported by the imputations of misconduct or misbehavior. The rule uses misconduct or misbehavior. It can include all those types of activities which can be a subject of inquiry. So without the imputations of misconduct, the charge does not remain a charge. Because if you see in criminal trial, how do we frame charge? We say you are guilty of so and so offense. Right? We do not tell who has said what. But in disciplinary proceedings, a little bit difference is there. You do not have a particular offense with which you can specify that and say the charge is complete. The imputations and the charge is a mixture of both. It contains that you have done this and what has been said and what you did which constitute this particular misconduct. That has to be there in the charge. You cannot say, oh, you were just, you committed an offense of theft, therefore so and so. Okay? It may depend at times when challenged that whether the person had the full knowledge of what he was meeting in defense. It's similar to criminal trial. You must not leave a doubt in your mind, oh, it's just a disciplinary proceeding, therefore I need not be elaborate on what charge he is facing. The principle still applies. The principle is that the defender must know with what he is accused of. So those primary ingredients should be there in the charge. And what are the imputations leading to that charge? Deliver such articles of charge. Now you cannot just frame it and keep it with you. It must be delivered to the, if the inquiry is delegated by the disciplinary authority by constituting an inquiry authority, then to that authority will in turn hand it over to the delinquent officer, or it can be directly delivered to him by the disciplinary authority as well. And that the charge when it is framed by the disciplinary authority, that time the delinquent is not present, unlike criminal trial. The articles of charge are there, it has been framed, and it must demand a written statement. What you have got to say on this. Okay? It is up to him whether he gives it in writing or desires to speak in person, but it must demand his reply. And at this stage also, the delinquent has a right to be heard. In a sense that, what I'm saying is he must be delivered the charge and must be said, okay, what you have got to tell. That completes his right to be heard at this stage also. As I said, disciplinary authority, DA, I'll call it, okay, it's a long word. DA may itself inquire into such of the articles of charge which are not admitted or appoint an inquiry authority to inquire into such charge. And the disciplinary authority also needs to appoint a presenting officer who will act on behalf of the disciplinary authority. It will present the case of the disciplinary authority. It could be a government servant or a legal practitioner. Okay? Now what if the delinquent officer admits in his written reply at the initial stage itself that yes, I have done it? Even when there is an admission by the delinquent in the written statement, it may be prudent to take evidence before entering the findings. In fact, the rule says, it's worded in such a way that you are required to take some evidence, even if there is admission, to enter into the findings. Because all admissions, if it is in writing that is given to you, may not satisfy you that this amounts to admission. The person who filed in written statement saying, okay, I admit to this. I think even in criminal trial, it's not sufficient to say I admit to the guilt. The ingredients of the offense must come on your record while the person is admitting. If he says, yes, I committed theft, that is not an admission of guilt. Yes, I did take the material or the object from someone's possession without his consent, must come on record to constitute an admission. So sometimes the authority might feel that what the person is admitting does not relate to the charge. Some people might give long answers in their reply, which you may be confused at. So it is always prudent, even if there is an admission of a sort, to take evidence and support those admissions before reaching the conclusion. Okay. Now what is the procedure then after that? Appearance of the delinquent within 10 days on the appointed day. Now, this I am going towards where the inquiry authority has been established. Even in case of disciplinary authority, if it's itself doing the inquiry procedure, it will adhere to those procedures which is there in the rules, and likely the inquiry authority is also required to adhere to the same rules. So the procedure remains the same, whether it is conducted by the DA or the inquiry authority so constituted. So once the inquiry authority is constituted and it also gets the articles of charge from the disciplinary authority, it needs to call the accused. I am not using the word summon. It's a very legal term. In the form of asking the delinquent to come could be of any form. It could be in a form of summon, it could be in a form of, it should just convey, you should appear before. Okay? There's no prescribed exact, though there are prescribed formats in the rule, but it does not mean that you have to stick to it. You can mold it according to the situation or the case before you within 10 days on the appointed day. You can appoint a day for his appearance. Okay, he can come before that also, he can come on that day also, there's no problem, but it should be within the first 10 days when you are summoning the person. Now, he can come before the, a written reply comes when the articles of charge is given. Okay, either to the disciplinary authority or to the inquiry authority. He files his reply, he or she. But then again, the next process comes, he can come to the inquiry authority or to this DA, and you can record whether he pleads guilty to it or not. The first form of reply where he can plead guilty is in the written form. Now in person he may come and also plead guilty before you, and you have to ask him whether he pleads guilty or not to the charges, articles of charge that has been framed against him by the DA. If he says no, then you, like criminal trial, must give it to the delinquent the proposed evidence of the authority. Though he gets all those materials along with the articles of charge as well. Okay, but the actual documents are before the disciplinary authority. You may give a photocopy of it, right? But you have to provide him the documents which are before you if he does not plead guilty. And once you give those documents when the person appears before you, there must be at least 3 days adjournment so that he can prepare his defense. You cannot do it before 3 days. After 3 days, anytime you can do it. It can be 15 days also, no problem, but at least 3 days adjournment must be provided under the rules under which we will inquire. Thereafter, the delinquent will also be asked to file his list of witnesses. Now this is some akin to civil procedure again, right? Filing list of witnesses. And if the delinquent feels that, for his defense he requires more documents which the DA has not provided, then he can give a written requisition for discovery of the relevant documents in the custody of the authority, but not a part of charge, if he desires to do so. Now, unlike criminal trials or even civil cases, the documents in disciplinary proceedings I have seen is very meager. Whatever is complained or whatever is given to the DA, unless some complaint comes, there is hardly cognizance by the DA that, oh, this person did this something. Or if the person is drunk outside, and has a brawl also, even if it comes to the knowledge of the disciplinary authority, it may not initiate proceedings, DP against him. That's something he did in his private affair outside office time. So there will rarely be, DA itself first inquiring heavily or investigating into the matter, bringing the evidence and giving it to the authority. No. Someone has complained it, and whatever they have produced, that is made a part of charge. Of course, the DA can always ask for additional materials from the complainant if it's inadequate to proceed further. But yes, sometimes that also may be inadequate for the person who is facing the charge, and he may ask for documents, certain relevant documents, which is there before the authority but not provided to you. Of course, these documents can be refused on the ground of security of the state or for any reasons which is recorded in writing. Now, during this process, similar to criminal trial, evidence starts coming in the form of witnesses, document, or it could be material objects also. The delinquent can cross-examine the witnesses produced by the DA or may not cross-examine also. However, he cannot engage a legal representative unless the presenting officer is someone who is a legal professional, or the DA can allow, or the inquiry authority can allow for special reasons to engage a legal practitioner for the delinquent. Ordinarily, you cannot engage a legal practitioner to defend yourself. You can engage a government servant, or you can, defend yourself. Usually, I've seen that they defend themselves. Of course, then what if we are someone who have studied law, we understand law, therefore it does not seem much big of an issue even when the legal practitioner is not engaged. But for some laymen, when they are dealing with the rules, they may have at certain times when the case is some difficult one, which has a big issue and is complicated, may require a legal practitioner. Therefore, there is no bar, but it is the authority which decides whether he can be represented by a legal practitioner. Of course, when the presenting officer is someone who has, the rule says, practicing, legal practitioner, the rule says, a legal practitioner just may not be a lawyer. Even if the DP is going for the judicial officers and the presenting officer is JO, someone, though he does not practice in court, but I would interpret him to be someone who is a legal practitioner, and in those cases, I think the person should get the representation of a legal practitioner. I think this has happened, you all know about one inquiry, right? In that one, the concerned officer was represented by a lawyer, probably because the presenting officer was a judge. Now in this examination it comes 313. I got so many calls once that saying that whether we should do 313. I had done this proceedings long time, but even at phone, I say I have to look into the book, but my general answer would be yes, you'll have to examine, why not? It's an opportunity to the person. So our rule expressly mentions that you have to examine the persons generally on the evidence appearing against you, just like criminal trial. So it's not 313 actually, it's examination of the person. Now sometimes what happens is, particularly in these days of electronic evidence, the DA would not be investigating like police and giving you all evidences which are electronic in nature, right? But there may be a situation where the presenting officer may feel that it needs more evidence to bring home the charge. In such cases, as is allowed in the criminal law, with the permission of the inquiry authority, new evidence can be brought in. But again, once this is brought in, there must be a clear adjournment of 3 days so that the delinquent can again look into the new evidence and prepare himself. So it almost follows the procedure of criminal trial, because it is one of those criminal trials procedures are one of those processes where maximum opportunity is granted. So in conclusion, you can just adhere to the principles of this criminal law regarding the procedure. If you don't find the exact procedure mentioned in the rule book, then you can stick to this. It's always prudent. You have given the person the vast opportunity to defend himself. Once that is there, it will be very hard for such proceedings to be forced. But if you say, no, I don't want to examine you, then that will be a very ground of again the inquiry coming back to you from the courts. Statement of defense and evidence. After that, the defense will be asked. Just like in criminal trial, if you see, there's no bar in asking the accused in criminal trial also, what is your defense? In fact, in NI Act, I think there's a judgment which says you must ask him his specific defense, right? So he'll have to say, this is my defense, and produce the evidence according to it. He follows the same procedure of that criminal trial. This I have dealt with. Okay, his examination is post his defense, right? Unlike criminal trial. After the delinquent closes his case and shall, if he has not examined himself, generally question him on the circumstances appearing against him in the evidence. Now, if he has not examined himself, means if he has not come as a witness for himself, then you have to do his examination. But even if he has examined himself, you need to do it. Because if you read this, this is exactly copied from the rule. After the delinquent closes his case and shall, it only stresses you must examine him if he has not examined himself. It does not say if he has examined himself, you need not examine him. So examination of the delinquent on the evidences appearing against him is a rule of procedure which you have to follow. Now, once the inquiry is completed, there will be a report prepared by the inquiry officer. All the roles of presenting officer, etc. is gone. And one more thing I want to tell you, there is no bar in hearing both the sides. The rules does not expressly say that you have to be heard before completing the report, but there is no bar. You can apply to this, and it will be much better if you hear both the sides, just like the argument which we have in the courts, because what that does is it gives the inquiry officer an opportunity to think from the viewpoint which particularly the officer may not have thought of. When you hear both sides, you get both views and your reason becomes more clearer while preparing the report. So it's always better to hear both the sides, and which we usually do. Assessment of evidence is the role of inquiry officer. Now this, evidence that comes in the disciplinary proceedings is to be tested in accordance to preponderance of probability and not for something beyond reasonable doubt. So it's akin to the procedure that is in the civil case. So evidence is assessed Just like, there may be situations where, nowadays 65, in criminal trial, 65B is required, right? Do we require in disciplinary proceedings? The law says preponderance of probability. Anyone missed Jwala? Do we require 65B in inquiry proceedings certificate if there is an electronic evidence? Yes, of reason you must give me. No, law of evidence does not apply at all to disciplinary proceedings. The Evidence Act does not apply.
But generally, principles of natural justice is what I'm saying. I think it will be prudent because there might be accusations of...
Yes, ma'am. No, ma'am. Aishwarya. Not required. No, I'll just give you an idea. Just try that, Evidence Act is not applicable to the disciplinary proceedings. We can decide it by strict rules of evidence, I would rather say, not Evidence Act. Strict rules of evidence are not required. So in criminal trials, we require that certificate 65B before the electronic evidence becomes admissible. So is it required in disciplinary proceedings?
I think it will depend on the facts of the case. What relevance does that electronic evidence have for that to come to a conclusion that...
Okay, yeah, I don't think that we can completely ignore that, not in a form of certificate, but some kind of, satisfaction that yes, this electronic evidence is true. Because we may not ask the form of 65B, but we may need something because, as we know, the evidences nowadays mostly come in electronic forms. And if this is not adhered to, you know how electronic evidences can be manipulated so easy. Right, so I think it will be prudent, at least to satisfy yourself, the electronic evidence that has come is reliable. Just because there is preponderance of probability, it does not mean that you cannot have a basis to reach that conclusion, even by way of preponderance. Okay, you may not require it. That's why I'm saying a form of 65B in that format may not be required, but some form of satisfaction is required in case of electronic evidence.
So, but what could be any other form apart from the form of 65B to satisfy ourselves?
What I'm trying to tell is, it may not be in the exact form. How criminal courts deal. If it is not in that exact form, we hesitate. Right? Usually it comes in that form. But insistence on what is the crux of that form? It says so many things for criminal trial. It must be produced from a computer or a series of a computer. Someone must certify it, etc. These whole ingredient of that is mentioned in 65B may not be required.
Just a mere certificate by the person giving it, authenticating that it has come in its proper form, it has been taken out, extracted in its proper form.
Yes.
That should satisfy given the preponderance of evidence.
Yeah, that could be, but still, while analysis, if we judges doing criminal trial, some executive may get satisfied, executive officer who is inquiring, but we have dealt so much with this 65B and we know the outcomes of the wrong electronic evidence, we may still not be able to act on it because, the electronic evidence being asked to be proved on the basis of preponderance may be too dangerous to proceed right. So this could be some kind of a big factor which has not become an issue so far in the inquiry proceedings, but to say, okay, just like, even I said, okay, let it not be in strict form. But while I sit to analyze it, would I be satisfied that what is being sold is true? Then probably I'll be discarding it. More so as the judges, because we'll have very hard time accepting that evidence. So that's a forum which can be discussed. Maybe Karma sir would like to say something. Because I have gone through this when the electronic evidence came, and though I argued that it is based on preponderance of probability, strict rules of evidence is not required, but the inquiry authority was still hesitant to use that material against the delinquent. And just like now, see, it's a mixture of civil and criminal. Findings on each article of charge. What this sentence reminds us about civil case? Yes, all issues must be decided. You cannot say, our issue says so and so, therefore I am not deciding this. In civil case, just like once we frame an issue, we must give a decision on everything. So findings on each articles of charge is also very essential, and this also has been one of the ground for quashing of the inquiry proceedings. There is no finding on the other charge, or remitting it back to the inquiry authority. So just like civil case, when issues have have to be decided, no matter it may be worthless. The fifth issue of yours may be worthless because you have discussed everything in the third one. Okay. So the importance lies also in framing of the charge. Therefore, if you had framed it correctly, maybe the fifth issue would not have been framed at all. Making over. Now, the inquiry authority, let's say, which has been delegated to function as an inquiry authority by the DA, does not hear the delinquent once the report is made against its own findings. It's the DA which can hear him, the disciplinary authority. When the disciplinary authority itself is the inquiring authority, then also the DA can hear against the findings. And he can make a representation, so and so has been done. And this is not what it ought to be. Now, what will the disciplinary authority do? If the disciplinary authority thinks that the delinquent has made certain observations on your report, which seems to be reasonable, and the inquiry officer has overlooked those things, then the DA can again remit it back to the inquiry authority for further inquiry and look into the gaps that are being seen apparently. Now, it's the DA which imposes the penalty, not the inquiry authority. Okay, so there are two types of penalties. One is major penalty, the other is minor penalty. Minor penalty includes withholding of increment, etc. Major includes termination, reduction of rank, etc. of similar nature, right? Now, there is in that syllabus, in that schedule, it also mentions appeal. No, I do not. I leave this to the group to discuss. If you see in our rules, whom you would to appeal. Though I don't see any provision for class A and B officers to appeal. Oops, I have my senior district judge here. Because usually also I have seen, the proceedings against the inquiry are challenged in writ petitions in the High Court. Of course, it must include violation of your rights when you challenge in the writ court. Now, when I see this, it says, class of Group A officers of the government, disciplinary authority is the governor, right? In jails, we can say the High Court. For district court employees, we can say the district judge. Power he is authorized to exercise all it says. Appellate authority nil for A and B. And for Group C and D, Chief Secretary. So I don't know how do we interpret this in the judicial side. Maybe Karma sir can help us on this. I have not seen appeals being taken up in the inquiry proceedings that we conducted.
So far as the district court staff and the High Court staff is concerned, I think there is a schedule in the rules which says that the appellate authority is the Honorable the Chief Justice for the district as well as the High Court officers and staff.
Okay. So the air is cleared by our senior judge that it is the High Court which is the appellate authority. Now, what would be the role of appellate authority? Can it replace the findings of the inquiry officer? It usually does not, but it has the power to remit it back to the inquiry authority or take a decision itself also based on reasonable grounds. It may not always have to be remitted back. Okay? So, person found guilty by the inquiry authority may also be not found guilty by the appellate authority. But it does not sit to replace the opinions and the conclusions of the inquiry authority. It sits to see whether there has been grave error or miscarriage of justice that no reasonable person could have reached to that conclusion. It is not like a criminal appeal that of course there is no bar in sifting the evidence that has come also, but usually on the administrative side we could rarely do that unless the findings are so grave and not appealing to the conscience. Now there is review and revision also in this. In case of, I think if that is there, appellate authority is designated as Honorable the Chief Justice, then the rule says review and revision lies with the governor. That can, that can be applicable in the case with the appellate authority which we have also. Does it talk about review and revision? We can check so far.
I'm not sure about review and revision.
Is that rule, sir, which subordinate court?
Yes, if it is not in that particular rule, then there must be another office note or a notification. If I'm not mistaken, I've seen that. And review and revision is also by virtue of, I think that it has to be done by the Honorable Chief Justice himself.
Yes, sir. Because if it says the governor in the case of the executive, 12 says control and discipline, and particular and without prejudice to the generality of this rule, the Sikkim Government Servant Discipline and Appeal Rules 1985, as amended from time to time, shall apply in matters of discipline and punishment subject to the following modifications. The expression government servant occurs in this rule shall be construed to mean the officers and members of the High Court staff, the governor, the Chief Justice. Okay, so it's here. But does this apply to district courts? Because it's just for High Court.
No. For the district court, it is not in the rules. Perhaps there is another office memo or a notification which is not appended to the rules.
Okay.
But if I'm not mistaken, I've seen it in one of the files.
Okay. So I think
there has to be an appellate authority.
So I think that memo would be essential if it's not available in the district judiciary, right? So we'll look into that and we can forward that to the concerned district judges also. It could be an office order of some kind. Okay. Now, number 2, as in appeal, nothing in this rule shall debar the Chief Justice from altering on appeal or otherwise an order of punishment, including adverse remarks recorded in a character roll or of appointment not provided for above, which may be passed by the Registrar General, or if the order is passed by the judge nominated by the Chief Justice, then before 2 judges comprising the Chief Justice and the remaining judge. So, what in case of JOs, sir, then?
In case of JOs, it is silent.
Okay.
The rule does not provide anything.
Because if you see the government rules, it says appointing authority is the government. Right? So ultimately it has to go there probably.
The appeal, I don't think it goes to the governor, because the controlling authority, so far as the judicial office is concerned, it is the Honorable High Court itself. And therefore, in case of judicial officers, in our rules, we don't find who is the appellate authority. And therefore, in most of the cases, there is either a writ petition challenging the order directly before the Honorable High Court and then before the Honorable Supreme Court.
So if you see this one, just like the Sikkim Government Service Rules has powers to exercise all. So this includes review and revision also if it's required. Though the provision of review and revision expressly is there in the government rules, on the what grounds it can be reviewed or on the what grounds it can be revised, those grounds may be taken here also as a part on which a review or revision can be done. But as I said, the High Court in a state being a ultimate administrative authority, and always in the rules there are some saving clauses there in case of difficulty, right? So those may come into play. As Sir said, if it does not go to the governor for JOs, then the administrative authority for the judicial officers, being the judicial Chief Justice, the highest, it can go there. And probably the another thing is that due to independence of the judiciary, it may be better that such proceedings are not sent to the government. So that could be one way of interpreting it. Right, sir?
Madam, we're just talking about the couple of months back, we had the case of Madhya Pradesh. She was in Madhya Pradesh being...
Okay, so that sir can also...
No, a couple of months, Madam, we're just talking about this incident where the judicial officers of Madhya Pradesh, state of Madhya Pradesh, were, I think, removed from this service, the lady judicial officers. So they filed an appeal directly before the Supreme Court against the orders passed in this regard.
So it could be terminated on the basis of inquiry or without inquiry?
I think there was an inquiry and it was found that they availed too much leave, something. They didn't have proper disposal. So because of that, I think their services were terminated, right? Then they challenged the orders before the Honorable Supreme Court. And the Honorable Supreme Court set aside all these termination orders that stated that they have to be reinstated immediately.
I think it could be they have challenged on the 136 could be, because that's such a wide power. Anything can go under 136.
If I may add on this point, because for judicial officers, if you see, if you go back and look at the
History.
let's say history of how the disciplinary proceedings against the judicial officers began, and earlier, as you all know, it used to be the governor of the state. The governor, even now it is the appointing authority, and earlier it used to be the controlling authority also for disciplinary matters, for promotions, and so on and so forth. And if you see, you may perhaps find it in the internet, and this is a case of Assam, where one of the judicial officer, inquiry was conducted, thereafter he was terminated, and so on and so forth. When this matter came before the Honorable Supreme Court, if I'm not mistaken, said that what is happening is for every promotions, for inquiry, these kind of matters, it becomes very difficult for a judicial officer to function. It affects the independence of our judiciary. So therefore, the entire disciplinary proceedings, promotions, this has to be under the control of the Honorable High Court. Thereafter, all these matters came before the Honorable High Court. And therefore, even you see our rules, we don't have the appellate authority as such, but the disciplinary authority, I think, is the Honorable Chief Justice.
Okay.
I'm not sure about that case, but you will find it in the internet if you search for that. It's Assam.
Okay, sir. So with this, I think we can break for tea. And I don't know, the second session, if you look at the topic, it's very general one. All may participate on this, right? Writing of ACRs is there, which I'll deal a little bit. And then the other is managerial skills in administration, etc. And one more topic is there. So that we can participate in discussion, unlike, it cannot be a one-sided judgment. The first one, appropriate person on discussing this, but yes, we all can involve. It says administrative issues and challenges, and the first bullet point is discussing qualities, attitudes, skills, and knowledge and application of alternate approaches. So in the morning I tried to find something on this. I think the overall tone of the topic is that, we are, especially in the executive, it's a more bureaucratic setup rather than private companies or private firms or private institutions where, the talent and the skills are more recognized and it has to be merit. But in the bureaucratic system, there may be, just like we have all experience on this. I'm just speaking the fact that many of the employees we have promoted would not meet the qualifications at times, but we are not strict with that. Okay? There's a DDC which considers certain things. The ability of a person is also taken account in promoting the employees. There are many factors taken into account. So, seniority. So the overall tone of this topic is that, what would be the managerial requirements in the district courts. Of course, without foregoing the requirement of that particular office setup, the structure which we have. The judicial administrative structure is quite different than what is there in the government. Right, we cannot leave that completely also, but we need in today's modern world when everything has been computerized to also recognize the merits of a person and his ability to do things efficiently. Otherwise, we usually do face, we are often as district judges, you will receive complaints also that a particular staff is not attending the office and you have not noticed it. Right, that will come, definitely come everywhere we go. And some say that particular is very close to district judge, therefore he or she gets what they want. So, to be frank, we are also not some kind of robots. There will be some kind of affiliation with certain staffs who are doing well, who are staying back with you in the office up to 7 o'clock if required. Sometimes they do come and ask you, okay, so I have some work, I need to go, sir. You may say yes. The person as the other day worked till 7 o'clock. These are not within the strict rules, okay? But there are so many such examples which all of us can think of. So this is a setup, right? But nowadays the judiciary is also considered as a sector which provides service. We have e-seva, Judicial Service Center. All these things are meant to provide service. So without losing the need to be serviceable, providing service, as well as the setup with judicial infrastructure which we have, the administrative infrastructure, right? We need to balance this, and we can discuss on this. Then next is the court and case management skills. For judges, this need not be taught, court and case management skills. Only thing my experience, especially in the Gangtok, is that there's a very much danger of file getting lost. Okay, and you sit down in the morning, what can probably you do? Can't do anything if the file is not produced before you. The witnesses are before you. And my experience is that, in the East, the file travels a lot of places, especially to that the copy section. And from there, it does not come back. In fact, in my case, ultimately the file was found after about a month. But the person who was responsible for releasing it from my office to the copy section, there was a signature in the register, but no one owned that signature. I was seeing that signature. I saw that register for the first time, in fact, when I was inquiring where did the file go. Then they showed me register that it has moved out from my office to the copy section. But the receiver's signature there in the copy section, supposed to be of some staff there, and also of my staff. No one said this is my signature, it's not me. So there was, finally I do not know how they got it, I did not inquire much, but they said they found it somewhere in copy section. So that is one thing. Another thing, that we do not know what happens outside our chambers. Right? We still deal with lots of manual files. And I have an experience, I'm speaking from experience, it's not a story. That there was one case, and it was put up for cognizance before me, and I read. It was about 3 o'clock in the evening, so I could not decide it at that moment because we had to calculate those dates and all. So I perused it, but since we are experienced, we catch things very fast. I could not find the dates in that one of the pages in that act petition to calculate when the check was bounced. So it was some murky. Then, okay, I said this requires time. I said put up for consideration tomorrow, and I'll take time tomorrow and see it by the evening, I thought. So I was pretty sure if that is not there, this case cannot be taken cognizance. Right? The next day the file was put before me. A nice paper was there. In fact, that page was there which mentioned the dates and all. Probably I talked in the office that, this does not constitute this. So, okay, then I was surprised. I asked everyone, who will own up? No one will own up, right? So, it's that, it's that the connection with the lawyers who come there, and somehow they managed to put that page. I was very much sure that page, it was not that page was not missing. They had not mentioned that fact. So I was surprised to see neatly last 2-3 pages were changed. So that is one incident. And the other is, usually the files are with the people who are not supposed to handle the case files. That is also there, because we do not know, because the other staff comes and tell you this fellow is doing this, giving the case files. And when you call that person and say, he or she says no. So these are certain, what comes to my mind in this case is when this topic case management is there. Otherwise the rest of the case management we know. So I do not know, very soon the commercial courts are going to be paperless. In a sense, we may not be having completely paperless if evidence is being recorded. But yes, all the commercial courts, including the court of CJ, as a commercial court, right? CJ court is commercial. We'll be getting this Wacom very soon. And then you will have to use that. I'm so sorry for the special division, I could not procure this because it was, they had said commercial courts only. So, but I tried, and I could procure one for JMist because thinking that a lot of remands take place from there, and It's one of the busiest and court with lots of cases. I've seen that in Jaipur. So we are giving it to Jaipur. But for special division, we have kept it for this financial year. Let's see if we can get it. So I think there's a notification from High Court that certain cases must be mandatorily e-filed. I don't know, that is not complied absolutely. Right, so we'll be having less papers in the future, but what I meant is that those case files are very dangerous for a judicial officer. Of course, there is a judgment 1 or 2 which says you can reconstruct it. More so we can do when we have this PDF versions of all the case records. But I think that also requires management, because in the busy courts you cannot every time deal with all the staffs and say, and it's not that everyone will listen to you every time. In courts as Gantok, we have seen administration since long time back. Very senior employees than us, right? So here it becomes a little bit of a balanced approach to handle the employees. With that, we can directly come to writing ACRs of officers and staff. Now, whether it's officers or staff, the type of ACR, I think it's about which group, sir? That ACR is written in the district court. B, right? C also. No, tribals is not written. ADS-C, I think. ADS-C. So we all have seen that ACR from, right? What we can comment on that? The form itself seems to be too meager to comment upon anyone, and no matter how much hard you try, the good comes there, because you have to circle, and if you have circled 3 goods, then average it comes to good only. I remember one officer who said in fact he wrote A++, because there was nothing that way. He felt that the employee deserves A and plus. So one of the officers has written A++, though it's not there, and his reasoning is that he deserved it, so there's no column or anything which I can mention there. So I do not know that. Those are issues, Otherwise, if you see, the first one says, one about health it talks, one is skills, and how well that person does a job, other than its regular one, and integrity, relation with staff, something, so and forth. So I think it's really inadequate to really just so when that document as such in ACR comes, then we don't have much scope to discuss about writing ACR. That is very easy to write, comment upon. But just yesterday when I saw this, I was feeling that how ACRs are written. Even if we say the relation of a particular employee with the other staff, then how do we know? Do we really know? We do not know. We are only assuming or perceiving that okay, his relation may be good just by generally looking into his usual behavior. And that is one there. Then health also, we determine by how many medical leaves does this employee take. That's the only ground. And other work, all the employees are engaged in their own work. We rarely put them to other official work. So there's really not a ground to determine as to the parameters which is given there. So we generally do it. Okay, and that leads to not marking what the person may have deserved on the positive side or also on the negative side. Because certain employees, I believe, need to be remarked the way they are, those who don't work. Otherwise they'll ride upon our back, and the next district judge would come and would also carry him. No, there are few people who really don't, who always want to skip office, and for some reason or the other, some come to ask permission, but they regularly come. Now you cannot say no also. They bring up such a situation to go to hospital, someone is ill, etc. And that becomes a regular feature with that person, so that the person knows, now district judge will allow me when I give this ground. And in about 15 days, once we may say, now you have been taking too much, but that will not halt that person. So writing of ACRs is very essential, I think, because it matters in their promotion when it's before the DBC. In fact, in ours also, if you see when we are filling up our ACR, we see the other part also of the reporting officer and the accepting authority. Those qualities, really you cannot mention in the one which you are writing. But what you are being gazed upon is the one which is there in the reporting authority's content and the accepting authorities. Some skills, relationship with the staff. How would an officer sitting up there would know that my relation with this staff. And I have no column for me to mention the facts which may lead to this conclusion. Now, having said that, now some may still want the present form of ACR because it does not create an issue. Because the more delicate we make, the more issues may come up, right? Because all the promotions, if you go by the rules, is merit cum seniority, not seniority cum merit. But usually in the bureaucratic setup, it is the seniority that takes precedent to some extent. So having said this, I open the floor and anyone, because once everyone is asking, it need not be on this topic only, judicial officers are here, we can discuss senior judges here, district judges are here. What do we need in an employee? A boss may be workaholic, right? But the staff may not. A boss may not be working. The staff would feel that no, why to work? The boss himself is not working. So this could be no. So how to balance this? And I think Karma sir is very good in balancing administration. We need to hear from him as a person also. That's why I'm saying. And he has been in the registry for so many years, which gives an extraordinary experience being there.
As new district judges, I feel, as a new district judge, I feel that managing the staff, the relations between the staff is like very, like...
Mainly it comes to leaves only actually.
Not only leaves, with regard to other things also, I mean like the way they are working. We can see the older staffs who've been working as special or stenographers, they still do not know how to, do their own work, which they've been doing for so many years. And if they're given once, extra work to do, they'll be like staring at you blank with a blank face. The stenographers also, they still do not know. We'll have to tell them, no, make it in the next page. Be like, enter.
Okay.
They don't know, don't enter, or they don't know how to align the page properly, or if a particular order sheet has stopped in one, this much of space and this much of space remaining, they will just leave it empty and then go to the next page. So all of that is still...
Actually what I find in this, we as district judges or even magistrates for the court, we have certain responsibilities apart from just deciding. We are responsible for everything that goes wrong. That's why we have gone into it and worked ourselves. But for the other employees, the response, let's take for stenographer. It depends on the person. Might only think that my responsibility is to type it. Okay, not to learn all those anything. And when I have experienced one thing, when you say that you are not doing these things properly, what they say, we haven't been trained. In the computer, in the people dealing with computers, it happened like that. They not complain. They said that we have not been given training, and it was a very simple thing. What training is to be given in that? So I think it is the sense of responsibility which the officers or the group C or D staffs would not have as much as we have. So they might think it differently. Okay, this is it, what I am to do, and I have done it over. But for us, so we expect that So maybe because if you see a district judge and your closest officer in rank is the administrative office, right? Who also comes from the other service, and if you see the pay scales, there's a huge lot of difference. So the place we occupy and they occupy appears to be quite different things. So these are, I think, these are problems actually. Okay, how to get this. Now, what this reminds me of the court managers. Actually, court managers are supposed to be a right hand of district judge, as per the document, as per the intention why court managers are being established all over the country. Because district judges use the actual intent behind posting court managers is that district judge has to do a lot of administrative duties. In other states, it's the main district judge, right? So, and the principal district judges who are almost very senior and about to retire. So now they won't be able to balance the cases and the administrative work. So the intent of the Honorable Supreme Court was that, see, let's give certain powers to the court managers which the district judge exercises in terms of administration, including signing of important administrative files, subject to the overall supervision of the district judge. Supervision takes away your daily routine work of signing files and etc. You can just supervise once a week maybe. That's the actual intent behind having court managers. So these developments are coming. It started with court manager. The problems which we are discussing led to having a court manager. So, but as we know, in our small state district, even we have played multiple roles as a judge also. So even the court manager here are playing multiple roles. In fact, Sushant was telling me, sir, it's a different, my role is different according to the book he was telling me, so I do not know. Yeah, according to book, yes, the roles are different. They are the right hand of the district judges. So when we can achieve that, we do not know, because still we have that structure of judicial system which is, which is very closed. All this requires openness. Right, so I do not know. Gap between the HOD, if we may say, and the next officer is also very huge in terms of rank, status, whatever pay scale. And lower you go, it will be difficult to tell that, tell a person and say, okay, you do this, do that up to 4:30 and all, you do your work properly. It's really difficult. They'll just say you sit in the office with that such high pay scale, and I am the one actually who is working down there with such meager pay scale. So, as an answer, we can say that's what destiny gave us or what our qualification gave. That's not my choice, but satisfying a person in work is really different than just giving orders. So I do not know. It's a difficult. You cannot do everything everywhere, I think. So Ma'am North also may be having some problems, right?
But I think for the newly recruited officers, I would like to state that, especially the ones who are posted in the subdivisions or even in districts where they don't have ATMs or court managers, like in Mangal, Gazing and all. I think for me, I gained my experience, administrative experience, quite a bit when I was posted in Gazing, where we didn't have an administrative officer to handle the administration. So it was just the district judge and myself who used to handle the entire administration, as well as even the accounting work. I used to also function as the DDO, as I think Ms. Jwala herself also, right? You didn't work, okay. Oh, because I was a DDO also. So I think that gives you a lot of experience. So I think I would really urge the new officers also, once they take charge of their subdivisions, their courts, they should be involved, because with now so many magistrates, I think the caseload has really gone down also. The courts being divided into many subdivisions. So if you handle even the DLSA work teaches you a lot of administration and even the office, like accounting work and all. And it trains you, I think, as you become a senior judge, you get into the Sikkim Superior Judicial Services, into the cadre. It trains you a little better than, being posted in a district where probably you have ATMs and all doing all the administration work. Like even sitting in DPC, you learn a lot about the service rules, the promotion, or as if you have been given some inquiry, you made the inquiry officer also. So that's an added bonus, I feel, and it shapes you as you become senior and you get promoted.
Skills and knowledge, as we are now moving into new recruitments and all. As Madam Ranjita said, some of the employees who joined service way back would not be able to perform their jobs. But I think the recruitments at present, in this LTR level at least, is being knowledge of computer is being insisted. That is a requirement, and the exam on subject computer is also being held. So maybe this will solve our problem to a lot extent. And knowledge also, I think there's a committee in the High Court which is looking into this rules of the district judiciary, whether it should be reframed or what steps can be taken to cure the problems there. That is also taking place. And any other thing? Yes, Ms. Urvashi, also you are Akyong. You may be having issues and you can share with us.
Not issues per se, but I would like to highlight on these Sikkim service rules, sir, as we are guided by that, regarding inquiring authority. If I'm not wrong, it says that the inquiring authority should be the person who should hold the position of joint secretary or above. So when it comes to our fraternity, I do not know how do we categorize that.
No, I saw that. Can you quote me the rule? I saw this.
I don't know, sir. It was long time back.
It is there, it's there, but I think that pertains to appointing a state inquiry officer. Just like I think the law secretary in the government does all the inquiries of certain level of officers. So I think when you are appointing a particular officer for inquiring into those, I think state inquiry officer when appointed requires to be at least joint secretary and above. I think that, I do not know how much.
So far as our rules are concerned, we don't have, we are not designated as to who will conduct the rules, but like you said rightly that ipso facto the state rules govern the so far as our service rules, and according to the state rules it is an officer above joint secretary and above. So for the state government, but it doesn't mean that that has to be taken entirely. At times we would have in our district court rules or service, we may not have an officer who is above the rank of joint secretary, or even as joint secretary. So we can also appoint an officer who is lesser in rank than joint secretary, but all that is required is the permission of the disciplinary authority, who will be the ultimate authority to begin the disciplinary proceedings as well as to close, and so far as punishment is
So
concerned.
the present administrative officers, what would be the equivalent rank in the government?
The equivalent rank right now, or administrative officers are of the rank of, once your basic
Yes, sir.
for the administrative officer is under secretary. And as you climb higher, you become a deputy secretary. And there are now administrative officers in our courts who have that basic salary after increments. They have reached that.
Okay, yes, because I think 19 is, pay level 19 is joint level.
So this is about one issue, sir. I'd like to just my own personal opinion,
Yes, sir.
since sir has opened this floor for discussion. I have been requesting all my, at least in Gangtok, all my colleagues that, and I would also like to request all the other judges here, so far as case management is concerned and your court management is concerned, is that the first priority that you give to a case when it comes to taking up your daily matters from your board, apart from victim, in any of the, apart from a child victim or whoever victim in sexual offences is concerned, apart from that, the first priority that you give is to the under trial prisoners. Because what happens is the under trial prisoners, they have to be brought, if there is a trial, from across the jail. They will have to travel a long distance, put it in your court, and normally what happens is they have their breakfast and then they come to the court. What we do, at least in Gangtok, is we finish their cases as soon as possible. So by 12 o'clock or 1 o'clock, almost all the courts are done with the under trial prisoners and they go back. Even in Gangtok, it takes about 1 hour to reach Rongek from the court complex because of the traffic and so on and so forth. But if they are late, sometimes it may happen that you are not conscious and you have taken up other cases according to your board, civil matters, these matters and that matters, and finally you take up criminal matters, and this under trial prisoner's case comes up at 3 o'clock. So by the time he reaches the prison, it's almost 4:35. So they have their dinner at around 4:30, 5 o'clock in the 5 o'clock in summer, and I think 4 or 4:30 in the winters. Sometimes they are given food, sometimes they go hungry, and there is no food in between. So my request to all is, I'm just, this may just be a general statement, but a request that take up their matters first, so that they can at least go home, go back wherever they have been brought, and they can have a proper meal for that day. So this is one, just
in this one, so one more thing that comes up, we are thinking from our side on the e-courts that under e-courts we have given VC equipments to the jail, but it was one set per jail, that was what was given. Now what happens usually is, I think there is only one VC set up in the jail, and usually they would give preference to the district judges court, and then the other magistrates would have to be waiting for that. So I think we have to increase that number of VC setups in this, so that at a time 2-3 accused can appear before the concerned court. Otherwise the JM gets the last turn. Naturally so.
Yes. So far
Naturally.
as remand is concerned, I don't think there is much problem, because remand normally we take up according to your time, or maybe 1 o'clock, I take up around 1 o'clock, the others may have their own timings. So remand is not a problem, but when they are physically produced for trial, 15 days remand, so on and so, that's not a problem. But when they are brought for trial, they come to the court, and when we don't take up their matters on priority, then I think that becomes, I'm sure all of us may have come across this, and this, I think, is one issue that we should keep in mind.
I mean, I think the new law that expressly permits the production of accused after the police custody remand through VC. I think previously it was expressly not there, though we were doing it. That can be done. And yes, I think the food, even if it is there, even if they've kept it, someone else eats that, but it happens in jail. So what sir is telling is true. In Gangtok especially, I think that will be really difficult.
That's right. And for other districts, I think they have to be traveling from Gangtok. Namchi, there is only two jails in Sikkim.
Travel from Namchi to BC.
Yes, for Yalsing, Soreng, they will have to travel from Namchi. And for Pakyong, Mangan, Rongli, or maybe Rangpu also, they will have to be brought from.
And they are already irritated. If you go down the Lokatala, that stairs you take, if you have to pass behind that Hazard you have, it's really difficult to cross that one. They are just bothered about who's going there. They're talking anything they want to talk. And if you see, most of the magistrates have visited jails, right? If you go into the cells where the convicts are kept of the heinous offences and the under trials of the heinous offences, they are almost mentally almost deranged to me. I would find that way. No one would talk to you, right? So, of course, when liberty is curtailed, that's the actual punishment. No? Within the boundary of that world, no one would mentally be sane out there. So I think, coupled with these things, when the food is not there, and we have heard of certain stories, I do not know whether they're true or false, that accuse, coming with an intent to harm the judge. Maybe seniors would know it. I will not say in this forum.
And maybe just some tidbits, if I may be permitted to speak. So whenever there is a remand for the magistrates, the reason why there was a remand room in all your quarters, your official quarters residences also, we have taken this into account. At one point of time during winters, I don't remember the year exactly, but I was a magistrate, and I was a duty magistrate then, and there was a jail break, January. It was vacation, I was on duty, so there was a jail break, and there were a couple of prisoners who escaped. And out of that, maybe about 5 or 6, they were arrested, they were brought. Now whenever there is an arrest here, they bring it to the nearest magistrate. Nearest magistrate is Gangtok. So I was here on duty, on my vacation duty. So I was in the hospital. My grandmother was not keeping well, and I was in the hospital, Manipal hospital. So they brought the prisoner. I saw, he was an accused, he was a convict under 302, and I saw him left, and then when he went out, later on the arresting officer told me that, sir, only later we realized that he was carrying a weapon. He was carrying a weapon behind, and what he said is, he gave the weapon and said that, I thought it was that judge who sent me to prison. Had it been that judge, I would have stabbed him or her. So that is one security aspect that you all should keep in mind, that whenever somebody is brought before you, first arrest especially, because once a person is arrested, you are first arrest, check him properly, only then to be produced before you. Otherwise there are some people who may not have any reason to also attack, so these are some safety issues that the magistrates also should keep in mind.
I hope the POCs of all the judges are healthy and strong. I don't know, I have not seen. We have not got it.
POCs,
They think that we don't need it because we
are
are
not in the spot or in your residence. Yes, in your chamber. Yes.
The commercial one is young one. I Maybe because as principal district just
By the
there.
time we are out of the vehicle, they're still. So, yeah, that is the situation.
So don't know, maybe thought it as a burden also, but I think it's a welcome step because
Yes,
being there someone makes a difference. No? You did not keep him every time with you, but having someone around and you'll
But
be
it's
able
only in the vehicle, sir, so it's.
No, it depends on someone was saying I don't want to use it. If you do that,
Clearing the traffic.
if you don't let it, then you'll never come. You'll stay at home. You'll get in the salary. Because people those are meant to work has to work. On the administrative side also, my experience is that if we, what do you say? In Nepali we say pull out. They stop working. And if you are good, then most of them will be taking advantage of it. And if you are not good at all, that person works till 9 o'clock and he is very good. I do not know what is this psychologically, but I have seen that. The more you make the person work, the more they work, and the less you make them work, the less they work. To versus query, I think what Sir said that we did not absolutely apply in our case also or applied. But to me, it is contained in the explanation to Rule 5. I don't think this relates to every time a new appointing authority is made. I will read it, okay? The state government, it's an explanation portion, may designate any officer in the rank of Joint Secretary to the Government of Sikkim or any higher rank to perform the role of inquiring authority as State Inquiry Officer to inquire into the case of disciplinary proceedings constituted under so and so rules. That rule, he may perform the duties as may be assigned by the government from time to time. I think this relates to only when you are establishing a permanent inquiring officer, State Inquiry Officer, who will inquire into all those cases which is sent to him. Otherwise, when there is a case basis appointment, I don't think this rule should be interpreted to include to those also. Of course, you cannot have someone who is subordinate to the person being inquired ordinarily to be an inquiring officer. It would be always better to have someone superior, right? But this, I don't think it relates to every case of appointment. It's only when one person is appointed on regular basis. Like as far as I know, Law Secretary inquires into the disciplinary proceedings of certain rank officers permanently as a State Inquiry Officer. So that's there. So anything else? I don't know. We cannot go early also, no? Because we have to think. What is the time schedule for lunch? For lunch.
1:15.
1:15. So we still have 1 hour. I do not know whether it's ready or not. And then.
If I tell,
No need to tell.
obvious to everyone.
It could be, but still I feel still you can manage it without telling the fact. It's possible. It's manageable.
Alright.
Because the point is the same, no? Whether you tell the facts or not, it's ultimately the law that is coming into play.
So I was just talking to you about a problem that I as a magistrate might face in the future. It's kind of a hypothetical issue. An offense nowadays, because there are lots of offenses like the recent case of Ranveer Allabadia. Some statement made in social media regarding which several FIRs were launched in several parts of the country. And then in that case, I think the Honorable Supreme Court stopped, restrained further lodging of FIRs against the accused. In such cases, what happens is offense committed through social media, the jurisdiction is, there is no definite jurisdiction. All the courts across the country can assume the jurisdiction. So in these cases, what happens is there are several FIRs lodged, and then one court, issues, suppose some warrant against the accused, and is put under detention. He is arrested, put under detention, and then other courts, they also issue warrants against the same accused. So in this case, the dilemma is that if the accused is detained under the order of one court, what is the course of investigation in the other?
If the police comes to you asking for remand because there is an
the
NPW
investigation
issued by
in
the
other
court,
cases,
right?
it will not proceed. So that is the question.
So anyone? Madam Subarna sir, Karma sir. I think I'm just opening the floor. The two questions that arise is whether as a magistrate at that stage when someone comes with the NBW Act before you, you can go into the background of the case and speak about the case, the several FIRs being there, and therefore it should not be. There should be only whether you can do that or not at the remand stage. That may come one thing. The other thing is, as you said, as in law we know it that FIR means one. It's the first information report. There cannot be multiple FIRs. So I do not, obviously the second informations will be ignored ultimately when it reaches the trial, right? So you have, I think, decision to make whether you can at that stage speak about this and refuse the custody because you are not recognizing the second FIR as a valid FIR. Probably legally valid. But as a magistrate we may refrain from doing it. I don't see any bar also in doing it when the law is apparently on your face telling something and not doing according to that law and following the regular procedure. Because there are certain cases, if I may say, there was one customs case while I was dealing. There was one order passed by a magistrate, I think it's a West Bengal only. He had passed such an order that, he was the first magistrate to say that the inquiry before the Customs Act was quasi-judicial in nature and it did not require strict rules of evidence. Therefore, the case not being proved there before the customs, what's the point of me framing the charge where strict rules of evidence is required? This was never a law before that. So he said, he is discharging the accused. He had other facts also. And ultimately in law he concluded that when the inquiry before the quasi-judicial body could not lead to his guilt, there is no point in trying case before me. Okay? And the materials are the same, he said. That travelled on. Ultimately, it was overturned in the middle by the other courts, higher courts. The Supreme Court said that the magistrate is absolutely correct in saying that particular sentence and therefore there is no need of interference. And the accused discharged. Whereas if you see the discharge law, it's something else, right? You cannot decide the probability of acquittal or conviction, which I find it quite weird as a magistrate. I have worked. There is nothing before you except we know the quality of our charge sheets. The story and the charge sheet is one. There is no material to support it. But somehow some hook is put there, and we do say prima facie. So that was the law. But this magistrate said something else, right? It went up to the Supreme Court and got upheld. So from my side, I think, of course, I have to do more study on what you are talking about. But if that's the case, I think we can, you can write what you're feeling is correct. If the second FIR has no validity in law, how can you allow arrest and remand? When you as a judge know the law, even though your particular work at that process of when you are dealing with the NBW application and arrest of the accused may be different. You would not look into, you would only look into unless Kumar 41, etc. usually. So that's my point of view.
So I think in this case we'll have to look into the party who was the complainant also. If a group of
No, there are different complainants.
No, if it's all from a group of people, like a particular group.
You can call them a group, they may not be also. Since I know the facts of the case, so I am not telling the name. But in this case, it is different complainants who do not know each other also probably. But they have a common interest.
I think it makes sense, because ultimately there has to be only one trial for one particular offence. If it makes out different offences, then yes, the other courts will have jurisdiction. But if it is the same offence, multiple FIRs all over the country, then the first FIR where it was filed, that will have jurisdiction over others. Because the trial has to be only one. Conviction, if any, should be only one, otherwise there is this double jeopardy as well.
Now allowing remand may be technically correct, right? Because we are following the procedure. There is an NBW issued by a court, a valid document, right? And then it leads to arrest, police want to arrest. Technically, you are allowing remand may be correct. But I think legally, you discussing that particular point of law and not allowing may be more correct.
I think we at that stage of FIR
Because ultimately it's not wrong is not to be done. Right?
lodging of an FIR at that stage and then granting remand is not, I mean, unlawful because
That's right.
like, if there is any
That's in the process
with
only.
regard to the quashing of the remaining FIRs, that has to be done by the accused or at a later stage. But initially at the investigation stage, I do not think so. We as, I mean, like the magistrates, no, they have that authority to.
That's what we open it to, we leave it to the concerned judge and then.
Because as per law, they are fine in granting the warrant.
No, that's why I quoted that previous judgment, when ultimately Supreme Court said what he is saying is correct. It took years to say that. But that was a correct decision. So ultimately, if sending him to custody, if in law ultimately it is, probably it will be said wrong, that he could not have tried in so many places or he could not have been detained, etc. Because if you see recent judgment regarding this remand only, where the procedure was violated in arresting the accused, the Honorable Supreme Court by majority have said, though by two separate judgments, that his arrest itself was illegal and his detention was illegal. So to that extent the law has gone. So as I said, technically what she would do might be correct. Okay, granting remand, there's a just so and so. But if legally you are feeling, no, this could be the correct one, though that's not the usual procedure, I think there's no bar in writing also.
But if the accused is granted,
It's not the first 15 days. That 15 days can be covered anywhere within that period.
The total 15 days is over.
yes. Because
If the total is over, then there is a ground for you to say, no, I can't give at all. Right? What could be a better ground than that? For 15 days, full stop, nothing doing. That would be the easiest one. They came for whole 15 days.
no, not that far. But then other
The
investigating agencies are from the other jurisdictional court.
No. If the 15 days is not exhausted, then 15 days can be covered later on also.
If the investigating agencies of each and every court where the FIR is registered ask for police remand, then
Yeah.
it could be a
That could be if actually it has crossed 15 days. Okay. Anything else?